Hi, everyone. I'm Zara. I'm an appellate attorney. I handle appeals in state, federal, and immigration cases. I also help attorneys in the trial and motion courts write their motions and memorandums, especially when they are setting up their arguments for an appeal later. Now, today I want to tell you about something I consider to be a pro tip from the appellate perspective. And uh, just the other day, one of the attorneys that I was helping review a motion for had a question about this. So I did a few revisions on his affirmation, and I told him that he should attach his memorandum of law as an exhibit at the end of his affirmation, so that it's an exhibit along with all of the other exhibits. And he took all of my comments, he accepted all of my changes, but then he called me and said, I want to talk about this because I've never heard of this. I've never seen this done. And I remember back when I had never seen it done, but I've seen it done a lot now, and I advise all the attorneys that I write lower court papers for to do this, and I'll tell you why. Under the New York appellate rules, if your memorandum of law is not an exhibit, it is not technically part of the record, and you can't include it in the record on appeal. Now, different parties like to play cute with this, and if they know you want your memorandum of law in there, they'll leave it out of the record. The appellant will, and vice versa. Sometimes an appellant will include the memorandums of law from both sides, and that's fine. It's not a problem, but it's not supposed to be in the record under the rules. So if your memorandum of law is not in the record and you ask the court to include it, they won't include it. So how do you get around that issue? You attach it as an exhibit, because every exhibit to every affirmation, every motion, is part of the record that goes before the appellate court. And this won't always be a problem. If you haven't done it in the past, don't worry. Start doing it now, though, and I'll tell you why. As you know, in the appellate court, you can only raise the issues, the legal issues that you raised below in the motion or the trial court. And there are some times, it's not often, but it will happen sometimes, that the argument that you make is in your memorandum of law and it's not in your affirmation. So the question will come up, did you raise that below? Now, you know you raised it below, and you'll be able to tell the appellate attorney who's writing the brief for your client for the appeal that you raised it below, but it won't be clear to the court. So to avoid any problems, and because it does not cost you anything more and there's no negative side to it, you should always attach your affirmation. No, you should attach your memorandum of law as an exhibit to your affirmation. I hope this was helpful. Again, I'm Zara. I do appeals in state, federal, and immigration cases. And I'll tell you another tip next time.